case law. The case law that we are going to look today is the case of Appiatse and Anor versus London Borough of Enfield. So let's start by setting the context of the case. This case took place in 2003 in London, England. So who are the people involved or the characters of the case? We have parents of a boy. We also have London Borough of Enfield. So why did this case take place? In simple terms, it took place to determine whether the decision to place a boy on child protection register was by reason of neglect was unreasonable. So we have said that this case was to determine whether the decision to place the boy in child protection register by reason of neglect was unreasonable. So we also were determining admissibility for judicial review process. So let us examine the case details. So the plaintiffs are parents of a boy born on 20th February 2003. The issue here was whether the decision to place the boy on the child protection register by reason of neglect was unreasonable in the Wednesbury sense. Okay, actually, you could scroll in the playlist and understand the meaning of Wednesbury and reasonableness. So, as we have said, the issue was whether the decision to place the boy on the child protection register by reason of neglect was unreasonable in the Wednesbury sense, and whether the wrong test was applied. Also, whether the complaints procedure that is available in such cases provided an alternative remedy so as to preclude judicial review. Let us proceed by looking at the facts of the case. The child was born on 20th February 2003. The child protection nurse's report says that the first time the child was seen face to face was in June 2005, and the health practitioner was shocked by the child's appearance. In July 2005, his mother took the child to a pediatric clinic, raising concern, among other things, about the size of the child. According to his mother, she was told that he needed to be force-fed and put on drip, and if he did not receive this treatment, he will die. In circumstances which are not clear on the evidence, his mother took the child back home that day. By section 47 of the Children's Act of 1989, a local authority has a duty to investigate when it has reasonable cause to suspect that a child in its area is suffering or likely to suffer significant harm. Paragraph 5 of the guidelines set out procedures for the handling of individual cases depending on the facts of the case in question. It is essential that both police and health professionals have access to register both in and outside office hours. Section 101 says that children should be registered under one or more of the categories of physical, emotional, or sexual abuse or neglect, according a decision of the chair of the Child Protection Conference. So here is the analysis of the case. The decision to place the child on the Child Protection Register by reason of neglect was not unreasonable in the Wednesbury sense, and the correct test was applied. So to know the meaning of Wednesbury unreasonableness, you could go to our video titled Wednesbury unreasonableness to get more info. The complaints procedure that was available in such cases provided an alternative remedy so as to preclude a judicial review. There was a significant material to justify the decision that was reached by the local authority that registration was necessary to protect the child. So the conclusion is that the claim for judicial review was dismissed. Thank you for watching this video. Like, share, and subscribe.